Thank you.
Good morning, Ms. Pieces.
May it please the Court, Judith Ellen Petrus for the Commonwealth. Yesterday I became aware of a decision from this Court citing to Ballou v. Georgia, and I'd like to bring it to the Court's attention. The site is Commonwealth v. Juvenile, and it's at 384 Mass 390 at 393. And in this 1981 case, this Court said that a jury of less than 6 persons would deprive a defendant of his right to a jury trial, guaranteed to him by the 6th and 14th Amendments.
Is that a case where it was done over the juveniles?
Correct.
But here, that case is distinguishable because here the defendant agreed to it.
Well, but the
And
difficult...
so did the Commonwealth.
So did the Commonwealth,
Well,
because there was no objection.
I would say that given our rules, unlike some of the other jurisdictions, particularly Montana, the Commonwealth has no role in determining whether a defendant can waive his right to a jury in whole or in part. What I would say is that the reading of the U.S. Supreme Court cases is that once you get below 6, you don't have a valid jury, you have a nullity.
But, Ms. Petrus, what's the, I mean, I have a lot of conceptual problem with thinking that it's okay to have a jury waive case with one person deciding, but it's not okay to have a jury case with 5 if the juvenile or the defendant agrees. Why?
Well, the U.S. Supreme Court had said that the essential functioning of a jury becomes decreased to
a juvenile has, you have to distinguish, at least in my case, and you're not going to get anywhere with me, if it's over the defendant's objection. So don't cite me to United States Supreme Court cases where the defendant didn't agree, right?
I agree that in the Supreme Court cases the defendant didn't agree, but the issue is that if...
Say, for example, you can cite me Miranda and to say, you know, and here the defendant waived his Miranda rights, but the Supreme Court has said that Miranda is essential. I mean, it's the same thing. You have to find a case where the defendant has not agreed to it.
But also, I don't mean to interrupt you, but adding to that, the Commonwealth didn't object. Isn't that key here? The Commonwealth didn't object to this proceeding, and I think they've waived any right now.
Well, I think the difficulty with that is that the prosecutor did not have the ability to confer legitimacy on the proceeding, so
but he could have raised
silence...
an objection. He or she could have raised an objection. I mean, if the proceeding is illegitimate in your views, of course the Commonwealth can raise that.
It could. Now, I would certainly...
But it didn't, and so isn't it too late now?
I don't believe it's too late because I don't think that what you've got here is a valid proceeding because you don't have a jury and you don't have a judge rendering a decision. You don't have a legitimate fact finder. So the fact that a brand new prosecutor who's been in the office for less than a year, which the judge would have been aware of...
That doesn't make any difference. That's your problem. If you don't train your prosecutors right, that's not... You can't raise that here.
I understand that, but his silence cannot possibly be construed to mean that suddenly this group of 5 becomes a valid jury. Because of what the Supreme Court has said. If it's a nullity, it's a nullity regardless of what he said or didn't say.
But the Supreme Court has not said that where the defendant has waived.
But there are so many constitutional rights that have to be waived in whole, so that an individual coming forward to render a guilty plea can't say, I'm going to waive all of the trial rights except the right of confrontation. Then it stops being a guilty plea. It can't be accepted. It's the same thing with Fifth Amendment. You can't say, I'm going to waive my Fifth Amendment rights as to this crime, but I'm only going to answer certain questions about the crime.
The defendant didn't do that. The defendant just waived his right to have a jury of 6. And in circumstances, by the way, which were not hypothetical, there was a jury of 6 impaneled, and somebody, a juror, after a full column.
That's the next
That's the next one.
Sorry.
In this case, they had exhausted the Venire at 5,
okay.
and they went forward.
So you're saying that our rule is unconstitutional in your view?
I'm saying that our rule is silent as to what happens in the district court because...
Well, but it says right at the top, this applies to district court and superior court.
Right, as does Rule 20, but then it doesn't talk at all about alternates in the district court. We have two conflicting statutes with the regarding of handling alternates for the district court, and Rule 19 doesn't indicate that because of the time when the rule came in, it was citing to a statute that only dealt with a jury of 12.
Would you agree that we could dispose of this case in about 3 sentences on the basis that the defendant formally accepted this and the prosecutor didn't object, and the defendant raises no issue about it now, and that is the end of that on procedural grounds?
Well, but
and then in the next case, we can get into the whole business of 5 versus 6 and so forth.
Well, but I think the difficulty with that is that if the court is taking a look at it, this is a time to say, and it may be that, as the court did say in Norrell, that the court may come down and say less than 6 is not a jury.
Well, whose constitutional right is this? Does the Commonwealth have a constitutional right to a jury of 6? I don't think so.
Society has a right to the orderly administration of justice.
And who enforces society's rights?
This court, and to some extent the Commonwealth, when it engages in a prosecution.
Of course it's the Commonwealth. And the Commonwealth can waive. The Commonwealth can waive endlessly.
But we can't waive and make a hybrid form of a fact finder when that's not a legitimate fact finder.
Well, is your argument essentially that the defendant can waive rights that exist, but he or she can't create rights that don't exist, and a 5-person jury doesn't exist? Is that essentially what your argument is? That's
exactly what our argument is. He's entitled to a fair trial by an impartial fact finder. He's not entitled to an evidentiary hearing in front of no fact finder, which is in essence what happened here, because he didn't have a bona fide jury, but he hadn't waived to go to a bench trial.
It would be somewhat akin to the defendant can go pro se, or he can have counsel, but he can't go midway.
Correct.
Well, in fact, he can't go midway. We do it quite often.
He shouldn't.
Well, you can have standby counsel, but I would liken it more to the Fifth Amendment right, double jeopardy. It's all or nothing. You either get that second trial and you agree to the second trial, or you don't. And I would say that the same thing is here. You either have a jury, which has to be at least 6 people, or you have a judge. But you can't come down into the middle, because that just does violence to the entire expectation.
And you say 19B doesn't apply because it was enacted prior to the creation of the 6-person juries?
No, the 6-person jury was in effect at the time that 19B was enacted, but 19B, according to the reporter's notes, is relates back to a statute that dealt only with the jury of 12. And so I think, and again, if you look at Rule 20, you'll see that while a number of these rules are applicable to both the Superior and the District Court, they make absolutely no provision for what the reality is in the District Court with the jury of 6.
Can I ask you this question? Amicus spends a lot of time talking about Chapter 234A, Section 68, about the waiving of the jury, a full jury, after jeopardy is attached, as it can be by agreement of the parties. So would you say that if the parties were engaged in a jury of 6 and one of the jurors got violently ill and had to leave, that 238A would not permit the trial to continue, even though Section 68 suggests if the parties agree it can continue?
Well, that's the next case, I think. Those are the facts in the next case.
Well, you said a jury of 5 is invalid.
Right. It's not a jury. It's a group of 5, but it's not a jury.
So 234A 68 is also not valid.
Well, it's not that it's not valid. It just doesn't have application to the jury of 6 in the District Court is the problem. For that aspect where it says that the parties can agree to go forward with less, that goes to the jury going forward on a jury of 11.
Ms. Petras, how many, if I remember this right, you have the Ballou decision and the subsequent one, and you have a number of states that have authorized this to happen, correct?
I'm aware of 4.
Where the defendant or the juvenile assents.
I'm aware of 4, yes.
And none of them has ever, the Supreme Court just has never dealt with your situation, correct?
None of the 4 states have had their decisions vetted by the U.S. Supreme Court. That would be correct.
So are you making a federal constitutional claim here?
It would be in part. It would also be the rules of court as to what constitutes a jury trial and what the ability is of a defendant.
Have you made a federal constitutional claim?
Well, it's the
I don't see that you have. So
well, it's the right to the jury trial, which certainly flows from the federal Constitution, but it also exists in the Massachusetts Declaration of Rights.
I think you're better off predicating your theory on either the state constitution, but more likely on a common law rule or common law construction of our rule. Otherwise, you're inviting a trip to Washington.
And I don't think, I mean, you've made reference to the Sixth Amendment, but you haven't made a claim that however our procedure operates, that that's unconstitutional. I mean, the typical argument is this is not consistent with the statute. If you think it is consistent with the statute, it's unconstitutional. You've made the first but not the second argument, correct?
Well, I'm saying that the U.S. Supreme Court has said that a group of five is not a jury. And so in that regard, it does flow out of the Constitution, but it also is, as Justice Graney said, it is common law, and it is our rule of procedure for what we have.
But you haven't made the claim that if we disagree with you, in other words, if we say this was permissible by reading a combination of the statute and the rule, you haven't made a separate claim that that determination is unconstitutional.
Correct.
Okay.
Correct. But the difficulty here is that when you don't have a bona fide fact finder, you're creating the ability for a defendant to make a waiver of a situation where he may believe that it's advantageous to him, but it erodes the integrity of the criminal justice system because you don't have the orderly administration, you don't have the reliability of the impartial thought.
I mean, the defendant is not in a position to kick people off the jury. I mean, these circumstances, it's not as though the defendant can control if somebody is going to get sick or there's some problem with the jury of six. That's not something within the defendant's control.
Here, this is not a situation where somebody got sick or somebody was kicked off. This is they exhausted the veneer. What they should have done was continue it on to the next day to finish it.
Let's take the following. We don't have a United States Supreme Court saying you can't do it. Somebody is charged, comes to court, gets permission to take a day off for work, maybe uncompensated. The witnesses are there. The defendant has brought his or her witnesses, and this is enormously costly. And then for reasons unrelated to the defendant, because the jury pool is exhausted, the defendant decides that he will waive his right. You still haven't told me why he can't do that except to repeat, that this is not a valid proceeding. This is not a valid proceeding. But there's no place that says that I can see that says the defendant can't waive that right.
But that has the defendant controlling the trial court to the point that he is creating his own mechanism for fact finding.
The Commonwealth can object. The Commonwealth can say, I don't want to go forward. And if it's not a valid proceeding, the Commonwealth, it would be absurd to suggest that the Commonwealth has no standing to raise a question that the proceeding is invalid. The Commonwealth runs a great risk. There are double jeopardy implications. If it turns out that say the Commonwealth really does want 6 people for reasons that the Commonwealth doesn't have to explain. It may decide that this is a close case and wants to make sure that you get 6 people. The Commonwealth can certainly say, I'm not prepared to do that. And I don't think the judge would, if the Commonwealth made a claim that this was an invalid proceeding,
That's different.
The judge would take that into account.
I would agree with the court that the Commonwealth could have said something. And in the perfect world, the Commonwealth would have said something. But the reality is that the language of Rule 19 does not give the Commonwealth the ability to object when the defendant in a jury of 12 situation elects to go forward with just 11.
But aren't you stuck here because the Commonwealth didn't object? I come back to that same point. The Commonwealth didn't object and it went forward.
I don't believe we are stuck because of the fact that this couldn't go forward. This was a structural error, or, if you will, a lack of jurisdiction. The court can't conduct an evidentiary hearing without a fact finder.
But you'd be you agree you'd be in a different posture if the Commonwealth had objected.
Absolutely.
You'd be making different arguments. You say, hey, we objected.
Right.
But you didn't here.
I don't see
No,
how you
we did
say-
not object below, and I'm stuck with that.
Why do you say this is jurisdictional?
Well, because of the fact that the court has jurisdiction to hear, and it was the argument with a jury of 12 being reduced to a jury of 11. The court still maintains jurisdiction because that's valid, and the U.S. Supreme Court has said that's fine, and this court has said that's fine. Everybody would agree with that. But the court doesn't have jurisdiction to proceed on an evidentiary hearing where there is no fact finder. There has to be a fact finder. And here, it becomes very circular.
But I was going to say, you're just using terms.
The problem is it flows from the fact that the Constitution, the Commonwealth has no constitutional right to this. The cases you cite from the Supreme Court of the United States all say in the language you quote that it's deficient because, quote, deprives an accused of his constitutional right. They don't say anything about the states having any constitutional right.
But there's society's interest in maintaining that system.
Where's that in the Constitution?
That society has an interest in the prosecution of criminal offenses?
There's a minimum number
What
of jurors.
provision do I look to find that?
The 14th. I think all of the amendments lead to what is in society's interest, in part in protecting a defendant, an accused, and in part of protecting everyone, to maintaining an orderly justice system.
The 14th is directed at individual rights, not collective rights of society.
Most of the rights are personal and individual, but all of those go toward creating a society that can rely and have confidence on a criminal justice system that is impartial and runs according to certain rules and has the basic components of a trial.
Ms. Pitts, let me ask you, where's the constitutional provision that says a jury of 5 is unconstitutional?
Well, certainly that would have come through the U.S. Supreme Court cases that has said that as it looks at the empirical studies as to how large a group you have to have in order to have the effective jury deliberation and the group dynamics.
To protect the defendant. I mean, we're going around in circles.
Well, it does get very circular, but the bottom line is if a jury of less than 6 is not a valid jury, then a defendant can't be, it turns into a kangaroo court, if you will.
Well, you're saying, I take it, that the jeopardy didn't attach because he could not have been placed in jeopardy because there was not a jury of 6.
Correct, because you didn't have the bona fide fact finder, and so you didn't have a trial. Jeopardy did not attach, and I would suggest that had the situation been reversed and had the defendant been convicted by this group of 5, we would be having the argument coming from his perspective, which obviously the court may have been more inclined to respond to, but if it's an invalid procedure, it doesn't matter which side of the coin we're on.
I think we would have said it was waived, but your time is up. Mr. Mintz.
Thank you, Chief Justice. Good morning, ladies and gentlemen of this honorable court. David Mintz for the defendant and appellee Zachary Dery. First of all, I'd like to address the Commonwealth's point that the prosecutor in this case had no standing or no legitimate position to take when they didn't raise an objection. And I would like to direct your attention and actually thank the amici on their brief to Chapter 234A, Section 68. That's a statute that clearly says, and I'm quoting, upon a finding of cause, the trial judge may impanel a lesser number of jurors than specified under this section. However, it has to be, it also says, nothing in this section shall prevent the court from rendering a valid judgment based on a verdict rendered by fewer jurors than required where all parties by stipulation have agreed to this procedure. So there needs to be a triangular agreement for this to take place by Massachusetts law. And in this particular case, there was such an agreement. The prosecutor didn't object. The defendant, for reasons that are set forth in the record, acquiesced to the procedure, and the trial judge conducted a colloquy and made the decision to go forward.
Really? But what happens if the prosecutor objected, the defense lawyer wants to go ahead?
I think at that point,
and the judge declares a mistrial.
At that particular juncture, I think you have a collision frankly, between a defendant's right to have his trial completed by a particular tribunal that's guaranteed by Wade versus Hunter.
Wait a minute. You wouldn't, at least in this situation, you wouldn't have a mistrial because you would just wait till the next day. And
That's
it
correct.
Certainly would not be manifest necessity here.
That's the,
in
you know,
this case.
that's correct. The judge, you know, it depended. If it's on a Thursday, usually there's no panel in my county brought in on a Friday. So circumstances are always dependent.
But why does the Commonwealth have any say in this?
Because the Massachusetts statute that talks about the law of the law in this situation basically says so, that it's by stipulation. I think I'm not necessarily going to take the position that the government doesn't have a right to an equal right to an appropriate adjudication. But I'm talking about this record, Justice Spina. This case dramatically turns on the fact that the government didn't object. Attorney Pietras makes a lot of issue of the fact that the statute that Rule 19 was based on was referred to the jury of 12 and was repealed in 1979. I think it's important to point out some timing here. Chapter 218, Section 27A, that was enacted in 1978, and it applied to the jury of 6 in all district courts effective January 1st, 1979. And I'm quoting subsection E. Trials by juries of 6 persons shall proceed in accordance with the provisions of law applicable to trials by jury in the Superior Court, except that the number of peremptory challenges shall be limited to 2 to each defendant. Now,
Mr. Mintz, let me ask you this. Although in Ballou it was the state, in that case Georgia, moving in this way, let's assume that the Commonwealth decided for efficiency reasons or cost reasons or because it wanted to not impose on the citizens to get called in for jury duty, that it authorized a jury of 5, right?
yes?
Is that constitutional under Ballou?
No, it's not, because and here's the distinction, because that's a situation where a state, by legislative fiat, is depriving the defendant of a constitutional right.
But it's only unconstitutional, presumably, because there's something about the fairness of the proceeding, correct?
Yes, and I would echo something you pointed out, I believe, Chief Justice Marshall. The fairness of the proceeding and the reasons elucidated in Ballou for not wanting to go below 6 all point to enlarging the risk of conviction of a defendant. So it all comes back to the fact that it's the defendant's rights that are being protected. And I'd also like to point out briefly that even the Ballou court said, and I'm quoting 435 U.S. at 239, we readily admit that we do not pretend to discern a clear line between 6 members and 5.
I understand, but they then go on for pages to say why, in fact, you know, you cannot, you know, at the margins you may not distinguish between 6 and 5. Let me ask you this. Let's assume that for whatever reason there was only one juror who could be impaneled, and the defendant says, fine by me.
Well, Your Honor, I would submit to you that one juror is not a jury. Jury is plural.
2?
Again, what I would ask this Court to do, I don't think there's a need for the Court to go beyond the record and engage in those hypotheticals, because I think it can be a very slippery slope, and it gets very difficult, I think, to distinguish among numbers. I think the case here is that...
Well, so I'm reading from page 241 of Ballou, right? So I'm not the 239 where I understand that Justice Blackmun said there's not a great deal of difference between 6 and 5, but the concern, the constitutional concern, was that a smaller group, so I don't know whether that's 2, 3, or 4, you know, does not have the ability to, quote, perform the functions mandated by the amendments. Well, if it doesn't have the ability to perform the functions mandated by the amendments, and that's the 6th Amendment, don't we have an impermissible proceeding?
No, I don't believe we do, because again, the government failed to object.
Well, that's different.
Attorney Pietras is...
You can try the pure waiver argument, okay?
Well, let me direct your attention then to United States, or Patton versus United States, and Commonwealth versus Lawless, a Massachusetts case that's cited in my brief. Both of those cases, and again, Patton plainly decided the issue as to whether the makeup of the jury was jurisdictional. That, of course, was a case that dealt with 12 jurors reduced to 11. But at the time, I think that was just as foreign to constitutional jurisprudence as the 6 and 5 situation we're dealing with here today. And the patent court clearly held that it's not jurisdictional, but instead, and I'm quoting at page 298, quote, conferred a right upon the accused, which he may forego at his election. To deny his power to do so is to convert a privilege into an imperative requirement. And the irregularity of a panel of 11 depriving a court of jurisdiction was also decided in the Lawless case, 258 at Mass 262. So the Commonwealth's assertion that somehow going below 6 people in this particular case deprived the court of jurisdiction is not supported by any law. And of course, the patent decision went on to consider the public policy argument. I think that's what Attorney Petrus is arguing here, is that there's some public policy that should guide this court and send you in the direction of essentially invalidating this procedure. And although, again, I note the distinction that they were dealing with 12 jurors down to 11 in Patton, but Patton soundly rejected the public policy argument.
Well, it also said it wasn't jurisdictional.
Right. Both of, and I would point to both of those aspects of the Patton ruling as being very important to your consideration of this case. And again, I would suggest that the Commonwealth's assertion that this wasn't legitimate was a claim, and I hate to keep going back to the waiver, but I'm envisioning this would have been a much nicer posture if the government had objected, and if the judge had said, no, we're going forward, and if the government had moved appropriately for a stay, and then we'd be here appropriately, I would suggest, under 211.3, and I think you'd have the case in the posture the government wants to suggest it to you. But it's not before you in that posture.
This is a little – this is a variation on that theme. I mean, you point out 234A, Section 68. Amicus spent a lot of time discussing that statute, which does require, at least as I read it, a stipulation of the parties to proceed with less than 12 or less than 6.
That would be my reading.
I think I read the statute that way. I mean, it's probably subject to some other variation. So are you suggesting, first of all, are you agreeing that the Commonwealth can indeed object to a trial of less than 12 or less than 6?
Well, I think that I think they certainly have the power to object, yes.
And that the court perhaps then could not proceed if the Commonwealth objected? Would you read
I think that would be up to the trial judge, I believe. And again, I think the Commonwealth does have. I think the Commonwealth has a right to object. They have a right to object on behalf of the people of the Commonwealth whenever they feel the procedure is irregular and need.
Didn't mean right to object. I mean a valid right to object.
Well, again, I think also, one has to look at.
You mean a veto?
A veto, correct.
Well, I think the statute.
Then it would present the question to us that arguably is presented here. Then we would have the direct question: can a jury of 5 decide the case?
But you would say, even if that were raised in that form, you would say the answer to that is going to depend on how you interpret the statute. It's not a constitutional or, some higher level of jurisdictional that something fewer than 6 means it's invalid.
That's correct.
It's just there may be a statutory right in the Commonwealth because of this language in 68.
Yes, and interestingly, I would point out something that I didn't discuss, but in the federal courts, by rule, there was a case, I believe, decided in the federal court where a defendant wanted to proceed jury waived and was denied the right to proceed jury waived because the Commonwealth objected. I believe the case went all the way up, I believe, to the Supreme Court. But in any event, the holding there was, the defendant's ability to have a trial in front of a judge only is not an entitlement, and the government, by rule, it does have the appropriate standing to object. So I do think that there's been some recognition that this procedural fairness issue is something that the Commonwealth has the ability to weigh in on. And in this case, obviously, they did not.
Well, whatever rights the Commonwealth has to raise this issue, if it has any rights at all, if it has the right to raise this issue, it arises out of Chapter 234, Section 68. In order to raise the issue, it has to have objected.
I would agree with that. I would agree with that. Whatever right there may exist. I would also point out there is obviously a countervailing constitutional right under Wade versus Hunter regarding the defendant, having the right to have his trial completed by a particular tribunal. There's some practical goods that underlie Chapter 234A, Section 68, and also obviously Wade v. Hunter. In the district court, oftentimes because of court calendar, you can arrive once and twice and your case might not be reached. You can arrive once and twice and maybe the Commonwealth's witnesses aren't there and there's a continuance. It can get very costly and very expensive for defendants to exercise their right to a constitutional, to a trial by jury. And in this particular case, obviously, it is in the record, the defendant had valid reasons to want to have his case, heard by this particular tribunal. Valid, strategic, and valid practical reasons. And that's the reason why the trial ended up going forward. Again, had the prosecutor appropriately objected, then the judge would have had a decision to make. And I think that's perhaps a more difficult situation. And you would have been presented with the issue squarely on an appropriate basis. I think on this record, I can't see the government getting past the fact that it didn't raise an objection on behalf of the people.
Mr. Muntz, I know that this isn't your case, but 234A, Section 68 doesn't set a de minimis, correct?
That's correct.
In your judgment, would it be advisable, assuming we were to agree with you, would it be advisable for this court to say, yes, assuming that we get past the waiver argument, yes to 5, but not to 4, 3, 2, or 1? Well, you've already conceded 1.
I guess I think it becomes difficult because again you're entering into hypothetical territory. I would suggest to you, Madam Chief Justice, that this is a situation that doesn't happen with frequency. In fact, in my 20 years, this is the first time I've ever seen anything like it, and I was so taken off guard, I had to look to the judge for guidance because, I'll be frank, I was the trial attorney, and I was not personally myself aware with the terms of Rule 19, which, by the way, I don't have to point out, but I will, that applies to a procedure where the jury of 6 has already been impaneled, and then it's reduced to 5. And again, one of the problems, just moving to the Nickel case briefly, is that they only impaneled 6 people, and there is a statute that says that you shall impanel an alternate. And I think this gives the court, I think, very clear guidance as to why that statute exists. I do see in the district court judges only impaneling 6, and I think perhaps one thing the court can point out in terms of both these cases is that the trial judges need to follow the rule and impanel 7 if they can. Obviously, in my case, the panel dwindled to 5, and that's what we were left with.
Did this case end the same day it was impaneled?
Yes.
So it was a one-day trial?
Yes.
As is typical in the district court.
I would agree with that.
Thank you, Mr. Muntz.
Thank you, ladies and gentlemen.